So good afternoon to all. Welcome back to the second day of the webinar on transformative changes under IBC and the related regulations. I am audible? I am audible?
Yes,
Hello?
sir. Yes.
Okay. And Anjali, I think my slide is also visible, isn't it?
First page is visible, sir.
ठीक है. Okay. I'll show that subsequently. Okay. So, yesterday, we discussed about the various changes, amendment made in the code earlier. We discussed the objective and purpose for the government of India to introduce the insolvency and bankruptcy code. We also discussed the report of the select committee formed by the motion passed by the parliament. On the IBC Amendment Bill 2025, we also discussed the committee formed by IBBI to see the recommendation of the select committee and to suggest the changes in the regulations of the IBC. Then we discussed the key highlights of the IBC Amendment Act 2026, and also very briefly we discussed some clauses with reference to the section. Friends, yesterday when I discussed with you, I mentioned that in case for the implementation of the Act 2026, the flexibility has been given to government for its implementation by mentioning in the notification which is issued to notify the amended Act 2026 that individual provisions of the section will come into effect as and when it will be notified by the government. Okay. Okay, disclaimer is there. So you know what's happened on 22nd May 2026, the Ministry of Corporate Affairs, they have issued the notification mentioning therein that almost all the provisions of IBC Amendment Act 2026 now have become effective, barring the provisions for your cross-border insolvency, group insolvency, CIARP, Creditors Initiative Insolvency Resolution Process, and that electronic portal framed by the central government for the process of the resolution. So, barring these four, everything is now notified and has come into effect from 26th May. The notification issued on 22nd May, and they said that from 26th May, the sections which are named in this notification, I think you can see it on your screen, will come into effect. Okay. Yes. So accordingly, we'll start our discussion on the new Amendment Act 2026. Good. So, initially I thought that I'll prepare PPT for my presentation, but later on I dropped this idea because, this time huge changes have been affected in the existing code. Sorry, it is no longer an existing code. It should be named as the Arch12 code, IBC code 2016. Because this time huge changes have been affected in almost in all sections of the code, either through amendments or by the insertion of new clauses and or the explanation to the sections. So what I'll do, I'll consider this gadget information where the various provisions of the new act has been issued or informed by the government. And side by side, I also discuss with you what was the provisions earlier by referring to my code book or IBC 2016. So I think it is okay with you. And I suggest you it will be better if you also have your code book with you, because these things will be reflected on my screen, the new provisions. But when I will refer to the earlier sections or earlier provisions to discuss the transformation, you will see the changes, what changes have been made by this new act. Okay. So the first one is section 3. All of you know section 3 is for the definition part. So after clause 27, the following clause shall be inserted, namely 27A. So this is new insertion. So, no need to refer the earlier book. So it is mentioned that registered valuer shall have the same meaning as assigned to it under chapter 17 of the Companies Act 2013. So only the definition has been provided now in the new act as regard the registered valuer. Now in clause 31, the following explanation has been inserted, namely. So let's see what was there in section 331. If you see your book, you will find that section 331, this is very important. This is also we discussed yesterday. This is for the security interest. And we have also discussed that rainbow paper, uh, case where the Supreme Court said that the creditor will also become a secured creditor through the operation of law. So in order, because, and so there is a conflict in the law and the judicial pronouncement. So in order to circumvent that thing, the necessary amendment has been made in the new act by putting this explanation under section 31, which is meant for the security interest. What does it say? Explanation for the removal of doubts. It is hereby clarified that the security interest shall exist only if it creates a right, title, or interest or a claim to a property pursuant to an agreement or arrangement by the act of two or more parties, and shall not include a security interest created merely by operation of any law for the timing in force. So what arguments placed by the Gujarat State VAT that we are also secured by the operation of law, because at the time of registration, it is mentioned that if there is a failure in the payment of taxes, then it can be recovered through the sale of assets of the company, and Supreme Court give recognition to this agreement. Now it is statutorily I mean, what should I say, that revised that decision of Supreme Court. It is incorporated in the law, in the act, that operation of law, interest created through operation of law will not be considered. Then again, it is a new insertion after clause 31. There is 31A, it says the service provider, they have defined the term service provider, means an insolvency professional agency, information utility, insolvency professional agency, information utility, registered valuer, and any person falling with the category of persons notified by the central government for rendering services in relation to insolvency and bankruptcy process under this code, and is registered with the board. So those persons will be considered as service provider. It is only for definition purpose. They put this definition. Maybe we'll see later how what is the importance of this definition, why it was mentioned. Now, section 5. Section 5 also, part 2, it is in part 2, and it is for the definition. This section provides the various definitions for part 2. Part 2 means CIRP, okay? So, first one is clause 2A shall be renumbered as clause 2B, thereof, and before clause 2B, so as to renumber, the following clause shall be inserted, namely 2A. Avoidance transaction means the transaction as referred to in section 43, 45, 49, and 50. So it is also sort of, the new act defines avoidance transaction more clearly, mentioning the particular sections which deals with avoidance transactions. After clause 9, the following shall be inserted, namely fraudulent or wrongful trading. Here also it is for the definition of fraudulent and wrongful trading, mentioning the relevant section in the definition itself. Okay. In clause 11, the following provisions shall be inserted, namely. Yeah, what is section clause 11? Clause 11 for the initiation date. So it is very important in the sense, all of us know that initiation date is the date when the application is filed before the NCLT to conduct the CIRP process, initiate the CIRP process. But in case where there are multiple applications filed against the corporate debtor and all the applications are pending, in that case, which date will be considered as the initiation date? This provision said that provided that where multiple applications for initiation of corporate insolvency resolution process in respect of a corporate debtor are pending before the adjudicating authority on the insolvency commencement date, the initiation date shall be the date on which the first such application was made before the adjudicating authority. So the first application date will be considered as the initiation date, and it is mentioned in clause 11 through a provision by the new act. Then it is clause 26 in the explanation for the word merger. Yes, 26 is the resolution plan. Resolution plan. So if you see the earlier explanation in the code, IBC code 2026, the earlier explanation for clause 26 mentioned that for removal of doubt, it is hereby clarified that a resolution plan may include provisions for restructuring of the corporate debtor, including by way of merger, amalgamation, and demerger. So, as per the explanation given for the resolution plan under clause 26, it is mentioned that merger, demerger, and amalgamation will also be considered for the revival of the company. Because, we discussed yesterday that uh, the the operation of insolvency resolution process is under two stages. First stage is revival through a resolution plan, and where the company should run as a going concern basis. But through this explanation, it was mentioned, even if it is a merger, amalgamation, or demerger, then also it will be considered that the company is on going concern basis. Now, what's happened? Now, the further more clarity is given in this explanation by mentioning for the words merger, amalgamation, and demerger. The words merger, amalgamation, demerger, just a minute. Merger, amalgamations, demerger, and sale of one or more assets of the corporate debtor through one or more plans proposed by one or more resolution applicant, subject to such conditions as may be specified, shall be substituted. So not only the merger or demerger or amalgamation, even the resolution plan key obtained for the different various assets of the corporate debtor. That also be considered as the resolution plan for the corporate debtor. Then clause 28. Clause 28 is for the voting share. Yes. So it is mentioned that after the words owed by the corporate debtor occurring at the end, that word to the members of the committee of creditors who are eligible to vote. Only these lines are inserted in that clause to denote the voting shares. Okay. So now we will discuss section 7 of our earlier section and what change this new act has made. We'll see that. So first of all, the section 7, subsection 4, the provision shall be omitted. I'll tell you the reason. So that provision is that adjudicating authority within 14 days of the receipt of the application under subsection 2 ascertain the existence of default. So as per this subsection 4, the NCLT to ascertain the default of the company, and now it is omitted because I think we have already discussed it yesterday that now the company, that now the intention of the code is that's okay. I'll just read it, then I'll explain. B, for subsection 5, the following subsection shall be substituted, namely, adjudicating authority shall, within 14 days of receipt of application under subsection 2 by an order, admit the application if it is satisfied that a default has occurred and the application under subsection 2 is complete and there is no disciplinary proceedings pending against the proposed resolution professional, or reject the application if it is satisfied that a default has not occurred or the application under subsection 2 is incomplete or a disciplinary proceedings is pending against the proposed resolution professional, provided the adjudicating authority shall, before rejecting the application under clause B, give a notice to the applicant to rectify the defect in his application within 7 days from the date of receipt of such notice from the adjudicating authority, provided further that if the adjudicating authority has not passed an order under this subsection within a period of 14 days from the date of receipt of application under subsection 2, it shall record the reason for such delay in writing. And two explanations have been incorporated under this section, subsection 5, section 7, subsection 5. For the purpose of this subsection, it is hereby clarified that where the requirements under clause A have been complied with, no other ground shall be considered to reject an application filed under this section. For the removal of doubts, then section 2 says, for the removal of doubts, it is hereby clarified that where a record of default in respect of a financial debt owed to a financial institution recorded with the information utility has been furnished along with the application filed by such financial institution, under this section, such record shall be considered sufficient for the adjudicating authority to ascertain the existence of default under this section. So the main point for this amendment or for this new section, amended section, is that now adjudicating authority, you have seen 4 is now deleted, omitted. So adjudicating authority is not now required to ascertain the default for which the application is made. What adjudicating authority is supposed to see, whether the application is complete in all respect, whether there is a default, whether the application is complete in all respect, and the name of the resolution professional who is named in this application, resolution professional who is named in this application, there is no proceeding pending against him. So if all these conditions are fulfilled, the adjudicating authority shall within 14 days, shall, this word may now deleted. The word shall has been mentioned in the new act. Within 14 days of receipt of application, approve it. Otherwise, it rejected, and if it reject, then it will give some time, 7 days time to the applicant to rectify the defect. But the main point is that now the adjudicator will only see this thing, and then he is bound to approve the application. Another very important thing has been mentioned is that here, if it is ever clarified where the requirement and have been complied with, no further ground shall be considered reject. No, sorry. Provided further that the adjudicating authority has not passed an order under subsection within a period of 14 days from the date of receipt of the under subsection 2 shall record the reason. This is, friend, this is also very important. Very important change. So if the application is not approved by the adjudicating authority within a period of 14 days, even if these conditions are fulfilled, or maybe whatever the reason, the adjudicating authority has to mention the reason in his order why it cannot be approved or rejected within the period of 14 days. Okay. Now section 9. Section 9 is the application for by the operational creditors. So in section 9, in subsection 3, in clause E, the words such other information as may be prescribed. The words any other information as may be specified shall be substituted. So for the words such other information as may be prescribed, now the words any other information as may be specified shall be substituted. So now if you see the draft regulations which is framed by IBBI, but okay, it is not yet, notified the regulations, but okay, we can see what is mentioned here. It is categorically mentioned for regulation 2B of CIRP regulation. The following regulation shall be substituted. So again, the relevant regulation is now substituted with a new one. To be information to be furnished by operational creditor, and an operational creditor shall furnish the following information along with an application with subsection 1 of section 9, namely copies of relevant extracts from GSTR 1 and Form GSTR 3B filed under the provisions of relevant laws relating to the goods and service tax, and the copy of e-way bill wherever applicable. So now the new act wants to make the applications more authentic by referring the documents which the supplier is bound to furnish or bound to submit as per the other acts, GST Act. So in the application, the operational creditor has to attach these two return form, GSTR 1 and GSTR 3B. Provided that provisions of this regulation shall not apply to those operational creditors who do not require registration, okay, and to those goods and services which are not covered under any law relating to goods and services tax. So, if it is not, if the supplier is not registered or not required to be registered, then it's okay. But otherwise, these forms are now what the word mentioned specified. So it is a specified document to be attached with the application filed by the operational creditors. Okay. The details of any partial payment received by the corporate debtor in respect of the operational debt and the date and such a payment. It is also to be mentioned. Details of assignment or transfer of operational debt, if any, along with the supporting documents. Details of any guarantee provided by the corporate debtor or any other persons in respect of the operational debt. A statement of account of the operational creditor with the corporate debtor showing the principal amount and interest, if any, due on such amount. A statement as to whether the operational creditor is a related party of the corporate debtor. Details of any other proceedings pending before any court, tribunal, because dispute, the operational creditor has also to establish whether there is any dispute or not. So now the documents to specified as the details of other proceedings pending before the court, tribunal and arbitral tribunal against the corporate debtor for the recovery of the operational debt is also specified as one of the documents to be filed with the application. Any other information which the operational creditor considers relevant to the application. So all these things are now specified, though the regulation has not yet been notified, but generally it is seen that when it is notified, when the regulations are notified, what is mentioned, very few changes are made in the regulations, which is already circulated as a discussion paper. Okay. Now, so it is okay. Now, in the subsection 5, after existing provision, the following provision shall be inserted, namely, provided if the adjudicating authority has not passed again the order under subsection within the period of 14 days from the date of receipt of application to under subsection 2, it shall record the reasons for such delay in writing. So now the timeline for completion of the process has given utmost importance. So here the adjudicating authority is also asked to state the reasons why it is not done within the time frame, cannot be done. Now section 10 is, you know, that it is the application filed by the corporate debtor through the corporate applicant. So in section 10 of the Principal Act, in subsection 3, in clause A, the word for such period as may be specified, the words and any other information as may be specified and shall be substituted. So if you see subsection 3, clause A, section 10, just a minute. The corporate applicant shall, along with the application, furnish the information relating to the books of accounts and such other documents for such period as may be specified. So, friends, if you now, again, if you refer to the regulation, because this is now amended, they said that for such period as may be specified, the word and any other information as may be specified shall be substituted. So if you see subsection 3, regulation and the proposed regulations has suggested for an amendment that after through an insertion, regulation 2D, after 2D, they advised that they recommended an insertion of a new regulation, in the name and style of 2E, submission of information by the corporate applicant. And there are lots of things. The corporate applicant shall furnish the following information along with an application under subsection 1 of section 10, namely following information relating to his books of accounts, and it is specified what are the following information from the books of accounts. The corporate shall also furnish the following documents: details of secured, unsecured creditors, everything, every money. Total financial position is now required by the corporate applicant to file with his application in order to have the approval from the adjudicating authority in support of conducting CIRP for his business. I am not going for all the details because this regulation has not yet been notified, and also you can see it. It is in the discussion paper of IBBI. I just want to touch upon these things. That all these things are already put into place, and moreover, it is now notified. All these things are now all these things have now come into effect. So clause B shall be omitted. Clause B is what? Clause B is the information relating to the resolution professional. Okay. Now the corporate applicant, in his application, is not required to name the resolution professional. You know that earlier the financial creditors and corporate applicant, they have to name the resolution professional in their application, but now it is not required. This clause B is omitted. In subsection 4, in clause A, the word no and no disciplinary proceeding is pending. And okay, this is since they are not required to name the resolution professional, so this portion is also omitted in the new act. No discipline proceeding is pending against the proposed resolution professional. Okay. In clause B, the words or any discipline proceedings is pending under the one also omitted. After the existing provision, the following provision shall be inserted, namely, so what is the existing provision? That provided the adjudicating authority shall, before rejecting an application, give a notice to the applicant to rectify the defects to his application within 7 days from the date of receipt of such notice from the adjudicating authority. And the following provision is now incorporated after this. Provided further, if the adjudicating authority has not passed an order under this subsection within a period of 14 days from the date of receipt of application under subsection 2, it shall record the reasons for such delay in writing. So here also it is mentioned that order has to be passed within 14 days time period by the adjudicating authority. So sorry, this section 11 has not yet been notified because I told you that CIIRP provisions have not been notified. So now section 12A. The following section shall be substituted, namely, subject to subsection 2, the adjudicating authority, just a minute. What is subsection 2A? For section 12A of the Principal Act, the following subsection shall be substituted, namely, 12A1, subject to subsection 2, the adjudicating authority may allow the withdrawal of an application admitted under section 7, 9, or 2 or 10 on an application made by the resolution professional with the approval of 90% voting share of the committee of creditors in such manner as may be specified. Notice anything contained in the law, the time being in force, and an application admitted under section 7 shall not be withdrawn before the constitution of committee of creditors. So, if you know that the system for withdrawal, which was there in IBC 2016, the earlier code, it was mentioned that the adjudicating authority may allow the withdrawal of application admitted under section 7 or sections 9 or section 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditors in such manner as may be specified. And if you see the existing regulations, just a minute. Just a minute. So I am sorry. So if you see the regulation, just a minute, 10A, 12A, sorry, 3. So if you see the regulation 30A, it is mentioned that it is mentioned 4 stages within which the application can be withdrawn. Application filed under section 7, 9 or 10. First is the when it is still, no order has been passed against the application. Second is when the order is passed, but no formation of COC has been made. Third is order passed and also the COC is formed. And fourth is before the invitation of EOI, expression of interest. So now what's happened? I think we discussed yesterday also that Baiju case, where Supreme Court categorically said that look, all the stakeholders are to be heard in the withdrawal applications. So in order to give effect of the judicial interpretation done by Supreme Court in withdrawal applications, it is mentioned it is incorporated in the new act that subject to subsection 2, the adjudicator may allow the withdrawal of application admitted under section 9, 7, 9, and 10 on an application made by the resolution professional with the approval of 90% voting share of the committee of creditors in such manner as may be specified. So only the second stage, that application is admitted and COC is formed, only that stage that application can be filed for the withdrawal. In no other cases, stages. So, notwithstanding anything contained in any law for the time being in force, the application admitted and shall not be withdrawn before the constitution of the Committee of Credit. It is categorically now mentioned in the Act. After the first invitation of the submission of resolution plan has been issued by the resolution professional. 3. The adjudicating authority shall pass an order under subsection 1 within a period of 30 days from the date of receipt of application. So, okay, here also the time frame is mentioned. But what thing importantly I want to mention you that it is also so this regulation 30 is also substituted by as per the discussion paper or as per the recommendation of the drafting committee of IBBI, it is mentioned that an application for withdrawal under section 12A shall be made to the adjudicating authority by the resolution professional within 3 days of approval of committee of creditors in such form as may be notified by the board through circular and shall be accompanied by bank guarantee towards the insolvency process cost. Okay, all these sections are named here of regulation 31 till the date of filing the application as determined by the resolution professional, that process cost. Where the application is approved by the adjudicating authority, the person furnishing the bank guarantee under sub-regulation 1 shall deposit the amount towards the actual expenses incurred for the purposes of referred to subsection. So these are all, so entered regulation 30 is now changed. Now proposed to be changed, and the new regulation 30A is now proposed to be inserted in the main regulation, stating that the application can file only after the formation of COC and with the approval of 90% COC members, voting share of the COC members. Another thing I want to tell you that look, in the regulation, draft regulations, the form FA is mentioned. So the new form FA is also mentioned or recommended in the draft resolution prepared by the IBBI, but generally it is said that the now onwards the forms will be only through sorry. Just a minute. Only through now the forms, all forms, required forms for the regulations for the process of insolvency resolution will be now come into picture through circular issued by IBBI and not through notification issued by the board. So you understand the difference. Now there will be no notification. Only circular will be issued for the different forms of the insolvency resolution process. But here the form FA is mentioned in the proposed regulation itself. Maybe seeing the importance of the form. So this is for 12A withdrawal application. Now section 14 is also important. You know, section 14 relates to the moratorium. In subsection 1, for the words brackets and figures subsection 2 and 3, the word brackets and figures and letters subsection 2, 2a and 3 shall be substituted. So, earlier it was only 2 and 3. Now it is 2, 2a and 3. What is 2 and 2? 3 is, I am telling you, 2 is your subsection 2 is supply of essential goods, and 3 is your provision of subsection shall not apply for what the central government in consultation with the financial sector regulate any such or any other authority. So 2 and 3 denotes that the essential services, essential goods or services, and 3 is for the financial sector. I mean, the items related to the financial sectors will not come under the moratorium. But now 2A is also where the interim resolution professional or resolution professional, as the case may be, consider the supply of goods and services or services critical to protect and preserve the value of the corporate debtor and manage the operations of such corporate debtor as a going concern, then the supply of such goods or services shall not be terminated. So that 2A is also now incorporated, which was not there earlier. Though 2A provision was mentioned in Code 2016, but it was not mentioned in subsection 1 of subsection 1 is for the adjudicating authority after submission of application under after admission of application under section 7 or 9 or 10 shall by an order declare moratorium for the purpose of for the purpose referred to in section 14, create a public announcement. Sorry. Subject to the provisions of subsection 2 and 3 of the insolvency commencement date, the adjudicating authority shall, by order, declare moratorium for prohibiting all or following. Okay. So the prohibition as per the earlier code is only for 2 and 3. Now 2A is also incorporated, which is meant for the essential services to run the things as a going concern. Okay. In subsection 3 in clause B, the following explanation shall be inserted. So subsection 3, if you see, the provisions of subsection 1 shall not apply, which we say that such transactions related to financial sector. So the explanation which will be after clause B, a surety or in a contract or guarantee to a corporate debtor. The provision of subsection 1 shall not apply to a surety in a contract of guarantee to a corporate debtor. So there is no prohibition for the surety of a contract to have its claim recovered during the moratorium period. But now it is mentioned in subsection 3 in clause B, the following explanation shall be inserted, namely, for removal of doubts, it is hereby clarified that the provision of subsection 1 shall also apply where the surety seeks to initiate or continue any action or proceedings against the corporate debtor pursuant to a contract of guarantee. So now the surety of the contract are also barred to initiate any actions against the corporate debtor during the time of moratorium. Okay. Which was earlier allowed. So that's why they incorporate 3 and they say that this for explanation is put in the clause B of subsection 3. Now, section 16 is the duty of appointment, appointment of interim resolution professional. For subsection 2, the following subsection shall be substituted. So, what was the subsection 2? Section 16, subsection 2 says where the application for corporate insolvency resolution process is made by a financial creditor or the corporate debtor, as the case may be, the resolution professional as proposed respectively in the application under section 7 or section 10 shall be appointed as the interim resolution professional if no disciplinary proceedings are pending against him. So it was the earlier provision. Now we have seen that section 10 application does not require to name the resolution professional. So in the subsection 16, which is appointment of the interim resolution professional, it says that a new subsection 2 is now substituted, which says that where the application for corporate insolvency resolution process is made by a financial creditor, the resolution professional as proposed in the application under section 7, only the 10 is now omitted, shall be appointed as the interim resolution professional if no disciplinary proceedings are pending against him. Sorry. What's that? Then it is said that after subsection 3, the following subsection shall be inserted. The new insertion 3A, where an application for the corporate insolvency resolution process is made, under section 10, the adjudicating authority shall make a reference to the board for the recommendation of a insolvency resolution professional who may act as the interim resolution professional. So now what's happened? After subsection 3, a new section 3A is now incorporated for the case of application filed by the corporate applicant. Okay. So where the adjudicating authority will make a reference for the board IBBI to name the interim resolution professional. In subsection 4, after the word brackets and figures, subsection 3, the words brackets and figures letter or subsection 3A as may be shall be inserted. So accordingly, you know what's happened in 4. 4 is for the board shall within 10 days of receipt of the reference from the adjudicating authority under subsection 3 recommend the name of an insolvency professional to the adjudicating authority against whom no disciplinary action are pending. Now that 3 also includes 3A. So if any application is filed under section 7 against whom there is a disciplinary proceeding is there, or the 3A application filed by the corporate applicant, in both the cases, the IBBI will inform the adjudicating authority name of the IRP, and it is now amended through subsection 4 of section 16. Section 18 is also very important, that section 80 of the Principal Act in clause B. Section 18 is the duties of interim resolution professional. So clause B said, receive and collect all the claims submitted by the creditors to him pursuant to the public announcement made under section 13 and 15. So you know that after the application is admitted, the adjudicating authority appoint the IRP and ask the IRP to make an advertisement for inviting the claim. So now what's happened after the words submitted by creditors to him? Submitted by creditor to him, it is the words in such manner as may be specified shall be inserted. I am coming to this letter. The following explanation shall be inserted, namely, for the removal of doubt, it is hereby clarified that the interim resolution professional, while collating the claims, shall verify them and, if required, determine the value of such verified claim. So now, if you refer to the relevant regulations, proposed regulations, it is mentioned, just a minute, manner of collecting claims received from creditors by the IRP. So the draft regulation says that it is observed that the insertion of the word in such manner as may be specified in section 18B expressly acknowledges the existing regulatory framework under CRP regulations governing submission, verification, and determination of claims. It is noted that Regulation 12, 13, and 14 of CRP Regulations 2016 already comprehensively specify in the manner in which the claims are submitted by the creditors. Such claims are to be verified by IRP or RP, and the value of such claim is to be determined, including provisional determination and subsequent revision where required. So everything is now changed or substituted. Submitted to him in such manner as may be specified. So what is the, so, and IBBI is the opinion, the manner is already mentioned in all the things, in all the regulations for CRP. So what they have proposed, the proposed amendment in the principal regulations in Regulation 13 of the sub-regulation 1A, the following sub-regulation shall be substituted, namely, the interim resolution professional or the resolution professional, as the case may be, after verification of claims, either admit or reject the claim in whole or in part, shall communicate his decision of admission or rejection of claims to the creditor within 7 days of such admission or rejection of the claim. So now it is the position of the verification of claims by the IRP and RP. Clear? Any question you have? Now we will come to section 19 in the, because I am telling you this section because I told you earlier that almost all sections undergo the amendment. Each and every section, they barring very few, it is also I have mentioned that section, which are not affected by the changes, but otherwise everything is, so we have to discuss the provisions of the new act very minutely. Section 19 is the personnel to extend cooperation to interim resolution profession. So what the new act says in section 19, the principle of the principal act, in the marginal heading, that the personnel to extend cooperation to interim resolution professional. Now, for the word personnel, the word person shall be substituted. Now it is the person, not personal. Okay. Personnel means only the employees, but there are other persons also who has to cooperate with RP or IRP for discharging his duties. B. For subsection 1 of the following subsection shall be substituted. So what was the subsection 1? The personnel of the corporate debtor, its promoters, or any other person associated with the management of the corporate debtor shall extend all assistance and cooperation to the interim resolution professional as may be required by him in managing the affairs of the corporate debtor. So here the personnel of the corporate debtor, its promoter, or the other person associated the management. But the new act substituted it with any person who is or has been a personnel. Any person, please mark this word very carefully, because all of you are IAP, so subsequently after this introduction of this act, when you go and exercise your assignment, you have to be very clear on the wording of the provision of the new act. Any person who is or has been a personnel of the corporate debtor, here is the employees of the corporate debtor, or its promoter, or associated, any person associated, not only personnel of the corporate debtor associated, any person who is associated with the management of the corporate debtor or engaged in a contract for service with the corporate debtor shall extend all assistance and cooperation to the interim resolution professional as may be required by him for the purposes of managing the affairs of the corporate debtor or performing the duties conferred on him under this chapter. So now it is not personal, it is the person. Person includes also the personnel of the corporate debtor. Okay. In subsection 2, the words any personnel of the corporate debtor, its promoter, the word brackets and figures, any person referred to in subsection 1 shall be submitted, obviously, and since the change is already made in subsection 1. In subsection 3, the words direct such personnel, the words brackets and figures direct such person to in subsection 1 shall be substituted. For the words resolution professional, the words interim professional shall be substituted. So if you see subsection 3, it is mentioned because the reason is there, I am telling you. The adjudicating authority on receiving the application under subsection 2 shall by order direct the personnel or other person to comply with the instruction of the resolution professional and to cooperate with him in collection of information and management of the corporate debtor. If you see the heading, it is mentioned that the personnel to extend cooperation to interim resolution professional, but here the word resolution professional is mentioned. So through this act, this resolution professional is now omitted, substituted with the word interim resolution professional, but through this explanation, after subsection 3, the following explanation shall be inserted. Explanation, what does it say? For the purposes of this section, it is hereby clarified that the references to interim resolution professional shall also include references to the resolution professional. So the basic idea of cooperation is covered both the IRP and RP. To be provided both the IRP and RP. Okay.
Sir, sorry to interrupt you, but nothing is visible in your screen, sir. It's a
Nothing,
blank page.
you cannot see my screen?
No, sir.
Hmm.
It's a blank page showing just a PDF thing, but nothing is visible.
Okay, I'll stop share and then I'll come again. But you should tell me this, Andy. Can you see it now?
No, sir.
No.
Any other participants who can see?
Is it visible to all? My screen? Hello?
Anyone from
No, no,
ICSA
it is
Institute?
not. It is not visible.
Not
Yes, sir.
visible. Anjali, it is visible or not?
Yes, yes, sir.
Visible.
No, it's not
The
visible.
PDF is not visible. The link of PDF is coming on the screen only.
So visible, but content is not showing. I think there is a page is
PDF, yes, PDF
visible.
file is not
PDF
open.
link is given there only.
Just a minute, just a minute, then just a minute, just wait for a second. Just a minute.
Anyway, we have already opened our PDF files, the amendment bill. So we are referring to that.
Is it now showing? Can you
Not
see
yet.
it now?
No,
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 sir.
sir. No PPT.
Wait, okay, wait for a minute. Just a minute, please. एक मिनिट.
So if you want, I can open that file from my system.
Just a minute. Just give me some time. I'm just talking. Okay. Is it now visible? Is it visible now?
No, sir. It is showing.
Hi. Yes, yes, sir.
Now it is visible.
Now it is visible. So, okay, okay.
Yes,
Yes.
yes.
I'm sorry, but you should tell me it earlier. ठीक है. So, section 19 we have already discussed. Now it is section 21. Please let me know when it is not, when it will stop showing in on my screen. Okay.
Yes, sir.
Thank you so much. So section 21 is the formation of committee of creditors. So after subsection 10, the following subsection shall be inserted, namely, where the liquidation process of the corporate debtor is initiated under chapter 3 of the committee of creditors constituted under this subsection shall also serve. We have already discussed it earlier that now the COC has given more power in the sense that now the concept of SCC is now taken off. And everywhere it is now COC. COC will now supervise. It is very important. I will tell you why. Because COC will now supervise the entire insolvency resolution process, both stage 1 and stage 2. And in liquidation, other creditors wants to participate, they can participate, but without any voting share. Till this amendment comes, it is the all creditors, all the members of stakeholder consultation committee holds a voting share as per their claim, percentage of their claim to the total claim. Okay. So it is mentioned that it is now only COC, provided the board may specify any other class or classes of creditors who may attend the meeting of the committee of creditors during the liquidation process, but shall not have any right to vote on such meeting. So, okay, we have to wait for the regulation of IBBI, but it is mentioned that somewhere I have seen that they can also attend, but without any voting share, the other creditors of the corporate debtor during liquidation. For the explanation, for the purposes of chapter 3, it is hereby declared that the provisions of subsection 11 of this section of section 34A and subsection 2 of section 35 as amended by the Insolvency Bankruptcy Code Amendment Act 2026 shall apply. This is very important, friend. Liquidation process of a corporate debtor initiated after the date of commencement of Insolvency Bankruptcy Code Amendment Act 2026 and the ongoing liquidation process of a corporate debtor as on such date of commencement where the liquidator has not made an application under section 54. So unless and until the dissolution application is filed, the provision of this section, the new section 21 will be applicable for the liquidation process which is ongoing now. So now it is only for the unfinished, unfinished where the resolution application is not filed, it is the liquidation process henceforth will now supervised by the committee of creditors, not the stakeholder consultation committee. Okay. Section 22 of Principal Act. It is, I think, meeting of the committee of creditors. No, sorry, appointment of the resolution profession. Section 22 of the Principal Act in subsection 3 in clause A for the words it shall communicate its decision to the interim resolution professional, the corporate debtor and the adjudicating authority, the words such person shall be deemed to be appointed. Okay, so let's see what is mentioned in subsection 3 in clause A of section 22. Subsection 3 clause A mentioned that where the committee of creditors resolves under subsection 2 to continue the interim resolution professional as the resolution professional, subject to a written consent from the interim resolution professional in the specified form, it shall communicate its decision to the interim resolution professional, the corporate debtor, and the adjudicating authority, that the interim resolution professional will now act as the resolution professional. And all of you know that the necessary order is to be passed by NCLT for the appointment of RP, isn't it? So what's happened when the COC passed the resolution, that IRP filed the application before the NCLT and NCLT passed the order confirming his appointment as the resolution professional. Now with this new act, it is mentioned the words such person shall be deemed to be appointed as the resolution professional from the date of such resolution passed by COC, and this decision shall be communicated to the interim resolution professional, the corporate debtor, and the board. So the adjudicating authority is not in picture now. For the appointment from the same person from IRP to RP, it is only to be informed to the board and also to the corporate debtor and to the that person. Clear? So it is also a very major change, because we all of you know that it is said that one of the reasons for the delay in the proceedings, IBC proceeding, is the overburden of the adjudicating authority. So, the necessary efforts have been made to reduce the burden on the adjudicating authority. Section 25, it is, I think, section 25, the duties of the resolution profession. Of the Principal Act in subsection 2 for clause J, the following clause shall be substituted, namely. So if you see subsection 2 clause J, substitute clause J said file application for avoidance of transactions. It is actually this section 25 is for the duties of resolution professional. And subsection 2 says that the purpose of subsection 1, the resolution professional shall undertake the following actions. And J said that the file application for avoidance of transactions in accordance with chapter 3, if any. So what's happened? They said that this is, earlier it is said that this is the duty of the resolution professional. The resolution professional should undertake the following actions. One of the actions is the file application and for PUFA, application, okay, avoidance transaction. Now what's happened? Now the new act says, file an application to the adjudicating authority in respect of an avoidance transaction or fraudulent or wrongful trading, if any, and so friend, you can see the changes. The changes is that now the resolution professional are empowered by his own to file the application. Earlier, what's happened? He made the observation that there is some avoidance transactions. He placed these things before the COC, COC approve, and based on the COC approval, they file the application before adjudicating authority. Now the new act says that RP is now himself is empowered as a part of his action to file the application to the adjudicating authority in respect of the avoidance transactions. So you can see the efforts now for reducing the time period in the entire process. Okay. Section 26. Of the Principal Act, the following sections shall be substituted. Section 26, the filing of an application in respect of an avoidance transactions. Okay, let's first see what is section 26. Section 26, the application of avoidance transaction not to affect the proceedings. So they said that if a application is filed for the avoidance transactions, the filing will not affect the continuation of the CIRP process, isn't it? So we can have we can continue the process. There is no matter whether the decision is taken on the perfect avoidance transactions or not. Any order has been passed by the adjudicating authority. Now what says? It says that it will be substituted by a new section 26, the filing of an application in respect of an avoidance transaction or fraudulent or wrongful trading, or under section 47, filing of an application in respect of an avoidance transaction or fraudulent or wrongful trading, or under section 47, shall not affect the proceedings of the corporate insolvency resolution process or the liquidation process as may be. So it is now very categorically said that not only the CIRP process, liquidation process will also not be affected by filing this application. And explanation, moreover, an explanation has been inserted in this section which said, for the removal of doubts, it is hereby clarified that the completion of the corporate insolvency resolution process or liquidation process shall not affect the continuation of proceedings in respect of an avoidance transaction or fraudulent or wrongful trading, or under section 47 as the case may be. So it is crystal clear that you have to file on your own the application towards the avoidance transactions, and this filing of application will not affect your continuation with the CIRP or liquidation process. Then section 28. Approval of committee of creditors for certain actions. Section 28. The following section shall be inserted, namely. So it is, you know, all of them, you know, what are the actions as per section 28 that we have to take the approval before the RP undertakes the those activities. It has to be approved by the committee of creditors first. So the new subsection 28A says, notwithstanding anything contained in this code or any other law for the time being in force, where a creditor of the corporate debtor has taken possession of an asset of a personal guarantor or corporate guarantor of the corporate debtor by enforcing its security interest over such asset under any law for the time being in force, which empowers the creditor to transfer the asset, the creditor may, during the corporate insolvency resolution process of the corporate debtor, permit the transfer of such an asset as part of the insolvency resolution with prior approval of the committee of creditors in such manner and subject to such conditions as may be specified. So now what's happened if a creditor holds the asset of the corporate guarantor or personal guarantor, which gives him a security interest, he can transfer this asset to the CIRP, Corporate Insolvency Resolution process of the corporate debtor from guarantor to CD with the approval of the committee of creditors in such manner and onto such conditions as may specify. Okay, the regulation will come here, but here what I want to tell you that provided where the corporate guarantor is undergoing a corporate insolvency resolution process or the liquidation process, transfer of the asset under this subsection shall take place upon approval of the committee of creditors of the corporate guarantor by a vote of not less than 66%. So whether the asset for which the creditor of the CD holds the security interest, whether that will can be transferred to the corporate insolvency resolution process of CD depends upon whether that personal guarantor or corporate himself is undergone with the CIRP or liquidation process. So if it is so, then the approval of that approval of the COC of that particular process has to be obtained. 60, not less than 66%, they approved. They, okay, you can take it, but again, I think it will be transferred. And the amount received pursuant to the transfer shall form part of the corporate insolvency resolution or the liquidation estate of the corporate guarantor, as the case may be. Here, what's happened if the corporate guarantor or the personal guarantor themselves are in CIRP or liquidation process, the realization from this asset will transfer to that process, not to the CIRP or liquidation process of the corporate. Clear? So this is through this insertion of new section 28A, the duties of the approval of the committee of creditors for the actions taken by the resolution profession. However, further, during the liquidation of the corporate guarantor, the approval of the committee of creditors under first person is required only when the creditor has relinquished such asset to the liquidation estate under section 52. Provided also that where the personal guarantor is undergoing an insolvency resolution process or bankruptcy process, and the creditor has forfeited or surrendered his right in relation to an asset, the transfer of such asset under this subsection shall take place upon approval by a majority more than 3/4 of value of the creditors of the personal guarantor, and the amount received pursuant to such transfer shall form part of the insolvency resolution process or the bankruptcy process of the personal guarantor, as the case may be, which I already told you. The transfer of an asset referred to in subsection 1 under resolution plan shall vest in the transferee all rights in or in relation to the assets of the transfer. Now comes section 30. In section 30 of the Principal Act in subsection 2, this is also very important. Section 13 is the submission of resolution plan. So in subsection 2, in clause B, the long line, the portion beginning with and provides for the payment of debt financial creditor shall and ending with liquidation of the corporator shall be omitted. So if you read subsection 2 in clause B, what is mentioned there? Any entity regulated by a foreign central bank or a securities market regulator or other financial sector regulator of a jurisdiction outside India, which jurisdiction is compliant with the Financial Action Task Force standards and is a signatory to the International Organization of the Securities Commission multilateral memorandum of undertaking. I'm sorry. I'm reading out the different thing. I'm sorry. Section 30 of the Principal Act in subsection 2. I'm sorry. In clause B. Section 30, subsection 2 in clause B, it mentioned provides for the payment of debts of operational creditors in such manner as may be specified by the board, which shall not be less than the amount to be paid in such creditor in the event of a liquidation of the corporate debtor under section 53 or the amount that would have been paid to such creditor if the amount to be distributed under resolution plan. So now what's happened, the new act says in clause subsection 2 in clause B, in the long line, the portion beginning with and provides for the payment of debts of financial creditors. Whichever is higher and provides for the payment of debt of financial creditors who do not vote in favor of the resolution plan in such manner as may be specified by the board, which shall not be less than. So it is talking about the dissenting financial creditors, how they will be treated in the resolution plan. It is mentioned in clause B in the long line, the portion beginning with and provides for the payment of debts of financial creditors and ending with the liquidation of the corporate shall be omitted. So this line will be omitted now. And what will be? After clause B, the following clause shall be inserted. So this clause B, this line, whether the higher provide and B, whichever is higher and provides for the payment of debts of the financial creditor who do not vote, these lines are now omitted and it is substituted by the and shall be inserted, namely after clause B shall be inserted, namely BA, provides for the payment of debts and the financial creditors who do not vote in favor of the resolution plan in such manner as may be specified, which shall not be less than lower of the amount to be paid in such creditors in the event of a liquidation of the corporate debtor under section 53 or that would have been paid to such creditors if the amount to be distributed under resolution plan had been distributed in accordance with the order of priority in subsection 53 as the case may be. And explanation: for the removal of doubt, it is hereby clarified that a distribution in accordance with the provision of this clause shall be fair and equitable to such creditors. Okay. Explanation 2 said, for the purpose of this subsection, it is hereby declared the provision of this subsection as amended by the Insolvency and Bankruptcy Code Amendment Act 2016 shall not apply to the corporate insolvency resolution process. Okay, fine. So what's happened now? What it is saying? It is said that it is mentioned already for the operational creditor that they will receive either the amount specified for them in the resolution plan or the amount they are entitled as per the waterfall mechanism. Okay. Whichever is lower. And dissenting creditors now they will receive the money or the amount should be provided in the plan. Lower of the two. This is the first time for the dissenting financial creditors, the lower of the security interest, they should be paid the amount such in the event of provide the payment of the debt of financial creditor who do not vote in favor of them in such manner as may specify whichever which shall not be less than the lower of the amount to be paid through in the event of a liquidation of the corporate debtor under section 53, or that would have been paid to such creditors if the amount to be distributed under resolution plan had been distributed. So the liquidation value of the security interest attached with the claim of the dissenting financial creditors or the amount which is provided in the resolution plan for this dissenting financial creditors will now be, the dissenting financial will now be entitled for this. Lower of these two. Am I clear? If you have any question, please ask me. And then say it should be fair and equitable. Any question you have?
No, sir, please continue.
Okay. So one thing I can tell you, because since this is a new act, and when ICSI, IIP asks me that whether I can speak on these things, I accept these things because I am also reading. I am also, so I really want an interactive session with you. Maybe my conception is also not clear. Some of you have more better idea of the new provision. So please come out and speak out on this. And don't make it a one-way traffic. Then will not, at least I will not be benefited from this webinar. Believe me, my intention to agree to this webinar only because of this, that, okay, first I have to study them, the new act. I have to study the comparison of the new act and the old provision. And also definitely I can interact with all of you. Anyway. So again, I told you, each and every section now amended. So earlier we have seen that though the amendment is made, but it is mentioned the Insolvency and Bankruptcy Code 2016. I don't know what will be named now. But the notification said the Insolvency and Bankruptcy Amendment Act 2026. I don't know. But each and every section of the code is now changed. In section 31 stands for the approval of resolution plan. In subsection 1, after the existing provision, the following provision shall be inserted. So if you see the provision, provided that the adjudicating authority shall, before passing an order for approval of resolution plan under this subsection, satisfy that the resolution plan has the provisions for its effective implementations. 32. Okay. Now the following provision, the new provision inserted also along with this provision. Provided further that the adjudicating authority may, on an application made by the resolution professional with the approval of the committee of creditors by a vote not less than 66% of the voting share in such form and manner and subject to such condition as may be specified, first approve the implementation of the resolution plan and thereafter approve the manner of distribution provided therein within a period of 30 days from the date of approval of implementation of such resolution plan. I think I told you these things yesterday. You know, it is seen that many times the approval of resolution by the COC takes time because of this. First, the plan approved, whether it comply with all the provisions, it comply with the provisions of section 12. Legal curing is done by the RP. So that takes time. Once everything is through, then COC also takes time for the distribution of money, which is mentioned in the resolution plan. And I think many of us have experienced that it requires a huge discussion amongst the COC members, how the money will be distributed. So, through this amendment or through this provision, it said that if it is so, COC may approve the plan first, submit it to the adjudicating authority for its approval, with the application approved by not less than 66% share of the COC, that this distribution of money will be approved later after the approval of resolution plan, but the time frame is mentioned within the period of 30 days from the date of approval of implementation of such resolution plan. So once the resolution plan is approved, within 30 days, the distribution of money should also be approved. Okay. In subsection 2, the following provision shall be inserted, namely subsection 2 is where the adjudicating authority is satisfied that the resolution plan does not conform with the requirement referred to in subsection 1, it may by an order reject the resolution plan. So this provision is mentioned, provided the adjudicating authority may, before rejecting the resolution plan, give notice to the committee of creditors to rectify the defects in the resolution plan. Earlier, there is no scope for giving notice. Now, the new act says, okay. Because, you know, the main aim to, and also the objective also, to revive the company. So, if the resolution plan is found defective to some extent by the adjudicating authority, before rejecting the plan, they send a notice to the COC members to consider it and to rectify it. Okay. After subsection 2, the following subsection shall be inserted 2A. The adjudicating authority shall pass an order under subsection 1 or 2 within a period of 30 days from the date of receipt of resolution plan. So again, the time frame is mentioned on the part of adjudicating authority that both this rejection and notice and the approval of the resolution plan should be passed within period of 30 days. Provided that if the adjudicating authority has not passed an order within such period, it shall record the reasons of such delay in writing. So, friends, let's expect that our life will be very easy henceforth. In subsection 4, in the proviso, the words prior to the approval of such resolution plan by the committee of creditors, the words, brackets, and figures before resolution plan is submitted to the adjudicated under subsection 6 of section 30 shall be substituted. After subsection 4, the following subsection shall be inserted. So the resolution applicant shall, pursuant to the resolution plan approved under subsection 1, obtain the necessary approval required under any law for the time being in force within a period of 1 year from the date of approval of the resolution plan by the adjudicating authority under subsection 1, or within such period as provided for in such law, whichever is later. The resolution applicant shall, pursuant to the resolution plan approved under section 4, provided where the resolution plan contains a provision for combination as referred to in section 5 of Competition Act, the resolution. Okay, fine. So you know what's happening? Earlier it was mentioned that if it is a combination or after the taking over the company, it comes under the purview of the Competition Act because of the combination effect. So the applicant must have the approval. Applicant, yes, applicant, not the resolution professional. Applicant must have the prior approval from the Competition Commission for submission of the resolution plan. There are the cases where it is mentioned that the approval was taken after the approval of COC and court rejects that plan. They said that, look, as per the provision of the Act, it should be prior to the approval of COC, and here the approval is taken after the approval, so it is rejected. So now what's happened? Now it says that not shall be inserted, notwithstanding anything contained in any other law for the time being in force and subject to subsection 6, where a resolution plan has been approved under subsection 1, a license, permit, registration, quota, concession, clearance, or a similar grant or right given by the central government, state government, local authorities. Sorry. The following subsection shall be inserted. Okay, the quota grant given by the central under any other law for the time being in force associated with such resolution plan shall not be suspended or terminated during the. Okay, I'm sorry. This is totally a different thing. You know, for actually the problem is that they have inserted these new clauses, new subsection. So, okay, which has no connection with the earlier one. So that is okay, that you have to, for combination, you have to take prior approval of the Competition Commission. But this is the new one. New one is that after 4.5 is that all the quota, licenses, everything which was granted to the corporate debtor earlier will continue. Local authority, other authority constituted under any other law for the time being associated with such resolution plan shall not be suspended or terminated during the subsistence of the remaining period of grants or rights if the corporate debtor, or if applicable, the person whose resolution plan is approved, complies with the obligation in respect of the remaining period of such grants or rights. So all the things will continue even after the approval of the resolution plan. If any license, permission, grant given to the corporate debtor, same thing will continue during its time period for the new entrepreneur also. Obviously, because of the going concern, isn't it? Where the adjudicating authority approves the resolution plan, unless otherwise provided in the resolution plan, any claim against the corporate. I thought this is the thing. This is very important because, you know, by this new act, the concept of clean set principle now introduced by the government of India. The reason is very simple. Nobody will be interested to submit his plan with the unknown liability. I don't know what will come in future. How do I submit my plan? So they said 6, where the adjudicating authority approves the resolution plan under subsection 1, unless otherwise, I think it is also a new subsection. They will insert. Following subsections, right? This is also a new subsection 6, where the adjudicating authority approves the resolution plan under subsection 1, unless otherwise provided in the resolution plan. Any claim against the corporate debtor and his assets under any other law for the time being in force prior to the date of approval shall be extinguished, and no proceedings shall be continued or instituted against the corporate debtor or its assets on the basis of such claims, including proceedings for assessment of the claim. So 2 explanations are given along with this new inserted sections. 3 explanations.
Sir, I have a question.
Yeah, tell me.
If there's a corporate debtor who has 100% subsidiary, and the resolution plan is for the corporate debtor, and the 100% subsidiary also comes along with the main CD, and there is a liability pertaining to the subsidiary. Say it may be an income tax liability. And so what happens to those liabilities which are actually, there, but they are in the subsidiary?
So, subsidiaries are separate, no? Separate entity. In the eyes of law, everybody has the separate entity. So the liability of the subsidiary will not come for the corporate debtor. The resolution applicant cannot take the plea that, okay, he is 100% subsidiary, so I will be immune from that liability. No.
So now, in the resolution plan, a specific relief and concession has been asked for, that as all the liabilities pertaining to the subsidiary also will stand extinguished, because this particular case which I'm talking about is actually a holding company, and the business is actually in the subsidiary company. Assets and liabilities and everything are in the subsidiary company. So the corporate debtor is the holding company. And then the reliefs and concessions, it has been specifically provided
to
that,
whom? To subsidiary or corporate debtor?
Subsidiary, that all the tax liabilities or whatever.
No, leaves and licenses provided to whom?
So no, all licenses are in the subsidiary. They are all part of the resolution plan. That the business which is being carried out by the subsidiary, which is technically being acquired through the holding company, and the corporate debtor is the holding company. So if you give me 2 minutes, I can explain the situation.
Yeah, tell me, no problem.
So there's a holding company which is actually running a real estate project. The land is parked in the subsidiary. The licenses are in the subsidiary's name, and the holding company has the development rights. So the resolution plan specifically provides for that the holding company will be acquired, along with that the subsidiary will be acquired, and the licenses will also go along with that. But there are certain tax liabilities which are there in the subsidiary, and in the resolution plan, specific provision has been made that in reliefs and concessions, that or any liability, any non-compliance, any tax liability pertaining to the subsidiary will also stand extinguished, because there is no point for any resolution applicant acquiring that company with that liability. So now, in the approval of the plan, there is no specific finding given by the adjudicating authority. It simply states that the liabilities will be as per law. So now, while dealing with the tax authorities, we are taking the plea of the Edelweiss and the decisions of SR Steel, saying that a clean state formula should be applied. So there should be no liability
Mm.
on the on. But I just want a clarification from you whether this stand will hold, that since the business was in the subsidiary and it has been acquired through the holding company, so there no liability is payable on the
Sir,
basis.
sir, what I gather from you, maybe we will discuss offline, but what I am gathered from you, according to me, the resolution plan, I mean, cannot ask for the immunity from the liability of the subsidiary. Subsidiary is a different entity. Okay. So that's why that concept of group insolvency will come. Maybe it will be covered under the group insolvency when it will be notified. But as present, that CIRP, the holding company cannot take any immunity from the liability of the subsidiary company. For the very reason that both the company, holding and subsidiary, are the different entities in the eyes of law.
Okay.
So I think, I mean, NCLT rightly said that it will be as per the law, what you said.
Yeah.
Because there is no provision.
Mm.
You can ask anything in your resolution plan, isn't it? But
No,
whether
but it has not been specifically denied also,
yeah,
saying.
fine, but the tax authority did not agree.
Mm.
Because of the very reason, but when the resolution for group company, group insolvency come, maybe we have to see that
Mm.
then. But at the present provision, because I told you that the group insolvency has not yet been notified. So at the present scenario, no, sorry, sir. I mean, no immunity can, for the tax liability of subsidiary can be taken.
Okay.
Even if the subsidiary is under CIP, then it will be different because of the, that assets of the subsidiary company will not come under the liquidation estate of the holding company, isn't it? For the same reason. If the asset doesn't come, why the liability will also come?
No, assets have automatically come.
No. Subsidiary company's assets are not come under the liquidation estate of the holding company. No, sir.
No. This is not this. My case is where the resolution plan has been accepted and the assets have come along with it through the subsidiary.
Agreed. Maybe you have given these things because then also that we have to see that thing, that whether I don't know whether that subsidiary is a corporate guarantor for the corporate debtor or not. If it
It is
it is a corporate, it
the
is a
assets.
guarantor.
Yeah, the assets of the
No,
assets were
it is a
sitting in the
guarantor for
subsidiary only, and
no.
the loan,
Both
the
at the
financial creditor
uh,
was of the developer of the property, and the asset the were mortgage of the subsidiary with the financial creditor. So he's released the security interest on that basis.
sir, I'll ask you to see the case of JP Infotech.
Mm-hmm.
It is categorically mentioned by the Supreme Court that
Mm-hmm.
the loan given to the JP Infotech
Mm-hmm.
by the mortgage of the subsidiary company,
Mm-hmm.
creditors are the financial creditor for the subsidiary, not the JP Infotech, because the assets now doesn't belong to the JP Infotech. It is always the asset to whom it is belongs to. Because all subsidiary company, everybody are separate entity. Yeah.
Okay.
So it is not possible. But okay, let's wait for the group insolvency. The purpose of bringing this group insolvency resolution provision is because of that. Because now the group wise it will be decided.
Hope it is retrospective. Anyways.
No, and hope it's everywhere. I just know I told you that in liquidation also. For the balance work, it will apply. The new act will apply.
Okay.
If it is not, true, or the plan is approved. The plan approved for the holding, I don't know.
Thank you, sir. Thank you.
Thank you. Now, section 33. Section 33 is the initiation of liquidation. In subsection 1, in clause A, the words, figures, or fast track corporate insolvency resolution under section 5 shall be omitted. So, because the very provisions of the fast track corporate insolvency resolution process is now omitted. All the provisions related to this are omitted. Okay. In clause B, in subclause 2, after the words in liquidation, the word and shall be omitted. So, in clause B, in subclause 2, the issue of public announcement stating the corporate debtor in liquidation and requires such order to be sent to the authority with which the corporate debtor is registered. So, no, and not and. They said and require the approval from the other who is registered. So, what the word and is only, and means, inclusive. So, there is no now inclusiveness. After subclause 3, the following subclauses shall be inserted, namely, subject to the provisions of section 52, that's security interest. Declare a moratorium for the purposes referred to in clause A and C of subsection 1, with subsection 3 of section 14, which shall mutatis mutandi apply to the proceedings of the chapter, provided the provisions of this subclause shall not apply to legal proceedings in relation to such transaction as may be notified by the central government in consultation with the financial sector regulator or any other authority, and pass an order appointing a liquidator for the liquidation process in accordance with section 34. So, what is said that after the subclause 3, the following subclauses shall be inserted. So, what is subclause 3? Required such order to be sent to the authority with which the corporate debtor is registered. So, it is an independent activity. You have to send the order to the authority with which the corporate debtor is incorporated. Then it is mentioned that subject to the provisions of section 52, declare a moratorium for the purposes referred to in clause A and C of section 1, read with subsection 3 of section 14, which shall mutus mutandi apply to the proceedings under this chapter. So, these things talks about the moratorium to be declared for the purpose of liquidation process, provided the provisions of this subclause shall not apply legally to the legal proceedings in relation to the financial sector regulator which will be notified by the central government in in the company under financial sector with the to be notified by the central government in consultation with the financial sector. Pass an order appointing a liquidator for the liquidation process in accordance with section 34. After subsection 1I, the following subsection shall be inserted, namely 1A. So, just a minute. Subsection 1 is the initiate where the authority before the expiry of the insolvency, then order for the liquidation, and now this new provision is incorporated in the act 1A, notwithstanding anything contained in subsection 1, where the authority, the various scenarios under which the authority will order for the liquidation of the corporator, where the adjudicating authority is satisfied that the grounds mentioned in clause A or clause B of subsection 1 of this section exist, it shall, before passing at the liquidation order, consider an application made by the committee of creditors in such manner and subject to such conditions as may be specified by not less than 66% of the voting share for restoring the corporate insolvency resolution process, and after considering such application, it may. So what is, I stop it here, and what is mentioned in clause A and clause B? Before the expiry of the insolvency resolution process period or the maximum period permitted for completion of the corporate insolvency resolution process under section 12 or the fast track corporate insolvency resolution process under section 56, as the case may be, does not receive a resolution plan, or B, rejects a resolution plan under section. So in both the cases, either non-receipt of the resolution plan or the rejection of resolution plan. So it shall, so in both the cases, whether resolution plan is received, not received, or rejected, but if an application is made by the COC with 66% voting share, can order for a restoration of the resolution process. Can order for the restoration of the corporate insolvency resolution process, and after such complete application, it may, by an order, if the grounds mentioned in clause A of subsection 1 exist, restore the corporate insolvency resolution process to be completed within such duration as may be deemed fit, but not exceeding 120 days, or if the ground mentioned in clause B of such subsection 1 exists, restore the corporate insolvency resolution process to the stage of invitation of submission of a resolution plan, which shall be completed in such manner and subject to such conditions as may be specified, and provide the duration or completion of such restored corporate insolvency resolution process as it may deem fit, but not exceeding 120 days. So this restoration of CIRP has to be completed in both the cases. Both the cases means where the plan is not received or the plan is rejected. In both the cases, within a period of 120 days. So again, this is some revival opportunities given to the corporate debtor. The explanation says, for the purposes of this section, it is hereby declared that on and from the date of commencement of Insolvency Bankruptcy Code Amendment Act 2026, the provisions of subsection 1A and 1B shall also apply to the corporate insolvency resolution process of a corporate debtor initiated under Chapter 2 before such date of commencement, where the adjudicating authority has not passed a liquidation order under subsection 1 of this section, and shall not apply where the liquidation order is passed. So once the liquidation order is passed, so these things is not applicable. 1B, the corporate insolvency resolution process of a corporate debtor may be restored in accordance with subsection 1A only once. It should not be, again and again, only once, 120 days. Best. Explanation: for the purposes of this section, it is hereby clarified that where the adjudicating authority does not receive a resolution plan under subsection 6 of section 30 within the period provided under clause A or clause B of subsection 1A or rejects the resolution plan received by it during such period under subsection 2 of section 31, it shall pass the liquidation order under subsection 1. So, okay. In subsection 2, after the word liquidate, the word or dissolve shall be inserted. So, subsection 2 says, reasonable provision at any time of the pass and liquidation order as referred to in section. So, now it is the or dissolve, liquidate or dissolve shall be inserted. For the brackets, figures and words 2 and 3, the brackets, figures of word 2, 3 and 4 and 5 shall be substituted. So, okay, fine. All these new things are now considered, and that's why the necessary amendments are made. Just a minute. Okay. For the words brackets, I am not reading this because these are some all the cosmetic changes. For the words brackets and figures of subsection 1, the words brackets figures letter of subsection 1 or dissolution order under subsection 2A of section 54 as the case may be shall be substituted. The following provisions shall be inserted, namely, provided the committee of creditors shall, before taking the decision to dissolve the corporate debtor, comply with such conditions as may be specified. In explanation, after the word liquidate, the words or dissolve shall be inserted. So, you know what's happened now, the COC can at any stage can take the decision to liquidate the company. But these things is mentioned that provided the committee of creditors shall, before taking the decision to dissolve the corporate debtor, comply with the not liquidate, dissolve. They can take the decision for the dissolution of the corporate, but shall comply with the such condition as may be specified. So the regulation will tell what are the conditions the COC has to follow for the dissolution decision. In the explanation, after the word liquidate, the word for dissolve shall be inserted. After the subsection 2, the following subsection shall be inserted. Shall pass a liquidation order under this section within a period of 30 days from the date of receipt of initiation of application, as the case may be, to initiate the liquidation process under this section. So here again the time frame is mentioned by a new subsection 2A. Provided that an adjudicating authority has not passed the order, it shall record the reason of such delay in writing. In subsection 3, for the brackets, letters and words 2 and 3, the bracket letters are 2, 3 and 4 and 5, 2, 3, 4 and 5 shall be substituted. Yes. In subsection 4, for the words, bracket, letters, this will be substituted. The following provisions shall be inserted, namely, provided where an application under subsection 3 is made, the adjudicating authority, if it deems fit, reinstate the corporate insolvency resolution process and pass the appropriate order. Okay. So what we already said, that it can, if it is application is filed by the 66% of the COC members, it can reinstate the insolvency resolution process. Subsection 5 shall be omitted. Subsection 5 shall be omitted. Subsection 5, subject to section 52, where a liquidation order has been passed, no suit or other legal proceedings shall be initiated by or against the corporate debtor. So this is now omitted. For subsection 6, the following subsection shall be substituted, namely, 6. We see what is mentioned in subsection 6. Subsection 6 is the provision of subsection 5 shall not apply to legal proceedings in relation to such transaction as may be notified by the central government in consultation with the financial sector. So the new provision said, where a liquidation order has been passed or suit or other legal proceedings shall be commenced, or if pending at the date of liquidation order, shall be proceeded with by the liquidator on behalf of the corporate debtor, except with the leave of adjudicating authority and subject to such terms as the adjudicating authority may impose. So it is for the continuation of the order. Of the litigations, subject to the approval of the leave of the adjudicating authority. In section 34 of the Principal Act, appointment of liquidator, for subsection 1, the following subsection shall be substituted. Where the adjudicating authority passes an order for the liquidation of the corporate debtor under section 33, it shall refer to the board for making recommendation of an insolvency professional to be appointed as liquidator, and on receipt of the recommendation, appoint such insolvency professional as the liquidator. Now, the RP is debarred to be appointed as the liquidator. It is also recommended by the select committee. And also, I mean, that recommendation is recognized, and it is also mandated by the new Act, amended Act 2026. So while the liquidation order passed, at the same time, the adjudicate authority will ask the board, that is IBBI, to name a insolvency professional as the liquidator. For subsection 3, 4, 5, the following subsections shall be substituted. Any person who is or has been a personnel of the corporate debtor or its promoter or associated with the management of the corporate debtor or engaged in a contract for service of the corporate debtor shall extend all assistance and cooperation to the liquidator as may be required by him. So it is that like section 19, no? So this is section 34. So notwithstanding anything contained in this section and section 34A, an insolvency professional appointed as a resolution professional for the corporate insolvency process under chapter 2 shall not be appointed. I have already told you. After an order of liquidation has been passed, a resolution professional shall forward to the liquidator all records relating to the conduct of the corporate insolvency resolution process. The board shall propose the name of the insolvency professional other than resolution professional appointed for the corporate insolvency resolution process under chapter 2, along with the written consent from the insolvency professional in the prescribed form. Within 10 days of the reference made by the adjudicating authority. In subsection 7, the words by an order shall be omitted. So it is now the order, it is as per the reference made by the IBBI. After section 34 of the Principal Act, the following section shall be inserted. So the new section is that where at any time during the liquidation process, the committee of creditor is of the opinion that a liquidator appointed under section 34 or this section is required to be replaced, it may by vote of not less than 66% of the voting share resolve to replace the liquidator with another insolvency professional subject to a written consent from such proposed liquidator in such form as may be specified. 2. Where the committee of creditors resolve under subsection 1 to replace the liquidator, it shall apply to the adjudicating authority for the appointment of the proposed liquidator, and if no disciplinary proceedings are pending against him, the adjudicating authority shall by order replace the liquidator appointed under section 34. So now the replacement of the liquidator will be done by the committee of creditors, not by the stakeholders consultation committee. For the various reasons, now the supervision will be done by the committee of creditors. In section 35, 35 is for powers and duties of the liquidators. In sorry,
Sir, I have a query regarding to the appointment of liquidator.
yeah, tell me.
Sir, so at the first stage only IBBI has to appoint. When there is a replacement, there is no need for the AA to inform like IBBI.
No, only thing the AA will see definitely inform because AA has to check whether any disciplinary action is there. You know what's happened? Generally, it is taken from the panel already submitted by the IBBI. So AA will not take any name from the panel. AA will only want to know that whether any disciplinary action is mentioned against that person is there or not.
And sir, at the first stage, when liquidation is initiated, that time COC cannot recommend?
No, no, no.
Okay.
It is only the AA. AA
Okay.
COC only can recommend once the liquidation process is started. After the replace, liquidator appointed, now COC wants to replace him. So section 35 is the powers of the liquidator. In subsection 1 for clause A, the following clause shall be substituted to maintain an updated list of claims of creditors in such manner as may be specified. In clause J, the words invite and shall be omitted. So now you know, as per the new act, liquidator will not invite for any claim. It will only update the claim. Update meaning you know now that only the interest portion should be freshly calculated up to the liquidation commencement date. Otherwise, that the list which is taken from the CIRP process will remain valid. So only updatation of the list will be done by liquidator and it will be supervised by the, I think it is mentioned, by the committee of creditors. So invite is not required. It is shall be omitted. For clause 1, the following clause shall be substituted, continue to institute proceedings in respect of an avoidance transactions or fraudulent or wrongful trading. The liquidator can also does it. The following explanation shall be inserted, namely for the purpose of this chapter, it is hereby declared that the provisions of clauses A and J of this subsection and section 38 to 42 as 38 to 42 related to all the claim verifications as amended by the Insolvency Bankruptcy 4 Amendment Act 2016 shall not apply to the liquidation process and voluntary liquidation process initiated on before the date of commencement of the Insolvency Bankruptcy Code Amendment Act 2026. So no claim verification, no claim invitation done by liquidator. For subsection 2 of the following subsection, the following subsection shall be substituted. So what it will be, the committee of creditors shall supervise what I just told you. Supervise the conduct of the liquidation process by the liquidator under chapter 3 in such manner as may be specified. In section 36 of the Principal Act, liquidation estate In subsection 3, in clause F, for the words proceedings from the for the avoidance transaction in accordance with this chapter, the words and figures proceedings in respect of an avoidance or fraudulent or wrongful paying under subsection 47 shall be substituted. Section 38, 39, 40, 41, 42 of the Principal Act shall be omitted. We have already discussed, no? They all are related to the claim verification. In section 43 of the Principal Act, just a minute. 43 is there, yes. In subsection 4, in clauses A to B, just a minute. 43 is your preferential transactions. So for the in section 43 Principal Act, in subsection 4 of in clauses A and B, for the words period starting from shall be substituted. For the words insolvency commencement date, the words initiation date and ending on insolvency commencement date shall be substituted. This is for the extortionate transaction. 26, 43 2, 43. Subsection 4 2 talks about the estimate. 43 4 2, yes. In section 43 of the Principal Act, in subsection 4, in clauses A and B, clause B talks about the preference to be given the person other than the related party during the period of 1 year preceding the insolvency commencement date. It is or it is given to a related party other than the reasons only for being an employee other. So sorry, I'm sorry. This is not the extortionate. It is for the preferential transaction. So preferential transaction period is from the insolvency the word insolvency commencement date, the words initiation of date and ending with the insolvency. During this period, you have to see the commencement preferential transactions. Okay. 46, in the marginal heading, the word available, the word undervalued shall be substituted. The avoidable transactions, the undervalued transactions. Okay. In subsection 1, for the words avoiding transactions at avoiding a transactions at undervalue, the words avoidance of transactions avoidance of an undervalued transaction shall be substituted. Cosmetic things. In clauses 1 and 2, for the words period starting from. For the word insolvency commencement date, the words initiation date and ending with the insolvency commencement shall be substituted. Now section 47, the Principal Act, the following sections shall be substituted, namely 47, where a preferential transaction under section 43 and undervalued transaction 45, extortionate transaction 50 or fraudulent transaction under section 66 has occurred and the liquidator or the resolution professional, as the case may be, has not reported it to the adjudicating authority. A creditor, either by itself or jointly with other creditors, a member or partner of the corporate debtor, as the case may be, make an application to the adjudicating authority to pass orders in accordance with the respective provisions of the chapter or chapter 6, as the case may be. So 47, it is there, but I have already told you that now it is empowered, RP is empowered, IRP is empowered, but this the new insertion, substituted section of 47 also said that for all these transactions, any person other than the liquidator or resolution, if they fail to make the application, then creditor either by itself or jointly with other creditors, members, partners can also file. Where the adjudicating authority, after examination of the application, is satisfied the relevant transaction is or trading under clause A or B or C or D of subsection 1 has occurred, it shall pass an order for the avoidance or trading as the case may be, and if such application had been filed by a liquidator or resolution professional in accordance with the relevant provisions of section 6. After passing an order under subsection 2, where the adjudicating authority is satisfied that the liquidator or the resolution professional, as the case may be, after having sufficient information or opportunity to avail information, did not report such transaction or trading to the adjudicating authority, it shall pass an order requiring the board to initiate disciplinary proceedings as the liquidator or the resolution as the case may be. Section 49 of the Principal Act in the proviso in clause A, after the word corporate debtor, the words or related party of the corporate debtor, as the case may be, shall be inserted. So if you see section 49 is transaction deferring creditors. And if you see this particular provision, clause A talks about shall not, the provision in the clause A after the word corporate debtor, shall not affect the interest of the property in the property which was acquired from a person other than the corporate debtor and has acquired in good faith for the value of the value or without another. Okay, fine. So if the property is acquired in good faith either from the city or the related part of the corporate debtor, then the transactions will not be considered as defrauding the creditor. Adjudicator shall make an order restoring the provision of the, provided that an order under this section shall not affect. So the order will not be effective. Section 52 of the Principal Act of subsection 2, the following subsection shall be substituted. You know, now there is no claim verification. So it is mentioned that the secured creditors will inform within a period of 14 days to the liquidator whether he will continue with his security interest or he will relinquish his interest. If it is not done within 14 days, then it will be deemed as relinquishment. Where the secured creditors intends to realize security interest under clause B of subsection 1, he shall inform liquidator of such security interest and identify the asset subject to such security interest to be realized within a period of 14 days from the liquidation commencement date. If he fails to do so, then such interest shall be deemed as relinquished to the liquidation estate. And provided, this is also important, where more than one secured creditor has any security interest over an asset of the corporate debtor, no secured creditor shall be entitled to realize his security interest unless the realization is agreed upon by the secured creditors representing not less than 66% of the value of the claims that are secured by such security interest. So if an asset is, the security of an asset is given more than one creditor, no one can realize the interest. It depends upon the approval of 66% voting of the secured creditors who are secured by the security interest of that asset. For subsection 8, the following subsection shall be submitted: the amount of insolvency resolution process cost and the liquidation cost, workman dues referred to in clause A and subclause 1 of clause B of subsection all this thing of section 53 respectively shall be deducted from the proceeds of any realization by the secured creditors who realize their security interest in the manner provided in this section. Only one thing I can tell you that earlier also this was there, but it was governed by the regulation. Regulation 21A said that the financial creditor who realize their security interest should bear the pro rata share, his pro rata share for what the CIRP cost and liquidation cost, including the liquidator fees. Now it is now incorporated in the act itself to strengthen this process. Okay. In section 53, I think we have already seen it because that DCF and DFC and operational. In section 53 of the Principal Act, in subsection 1, in clause B, in subsection 1, in clause B, in subclause 2, the following explanation shall be inserted, namely, for the removal of doubt, it is hereby clarified that where the value of security interest relinquished by the secured creditor is less than the total debt owed to such secured creditors by the corporate debtor, he shall be secured creditor to the extent of value of such security interest determined in such manner as may be specified, and for the remaining value of the debt he shall be considered to be an unsecured creditor. So again we have to wait. Explanation is given, but we have to wait for the necessary regulation. In clause E of subclause 1, following explanation shall be inserted. For the removal of doubt, it is hereby clarified that any amount, whether or not a security interest is created to secure such amount by an act of two or more parties or merely by the operation of law, okay, we have seen, due to the central government and the state government in respect of the whole or any part of the period of 2 years preceding the liquidation commencement date shall be distributed under this subclause, and any remaining amount, whether or not such security interest is created to secure the amount due to the central government and state government, shall be distributed under clause F. So for 2 years, you know, that is also there in the earlier code, that now the government authority will only be considered as unsecured creditors, and for their dues for the 2 years will be in the priority number 2, and for others it will be priority number 4. In subsection 2, the following illustration shall be inserted, namely the workmen and secured creditors of the corporate debtor have a contractual arrangement which provides that in the event of insolvency or liquidation of the corporate debtor, all debt owed to the secured creditor shall be cleared before the clearing of any debt owed to the workman. Such a contractual agreement shall be disregarded. So what is mentioned in the waterfall mechanism is now made more clear through the illustration. Section 54 is dissolution of the Principal Act. For the subsection 1, the following subsection shall be substituted. The liquidator shall completely liquidate the assets of the corporate debtor and make an application for the dissolution to the adjudicating authority within a period of 180 days. Here the timeline for completion of liquidation process has been reduced drastically. Earlier, I think it was 1 year time, but now it is only 180 days, and it can be extended for a period of 90 days only. where a proceeding in respect of the avoidance transaction or fraudulent or wrongful or under section is pending before an application is made under subsection 1 or a decision is made to dissolve the corporate debtor under subsection 2 of section 33, the committee of creditors shall determine the manner pursuing such proceedings and the distribution of the proceeds arising out of the proceedings in such manner and subject to such conditions as may be specified. Where any suit or other legal proceedings against the corporate debtor in respect of any proceeds to be distributed under section 53 is pending before the application is made under subsection 1 or a decision is made to resolve the corporate debtor under subsection 2 of section 33, the committee of creditors shall make appropriate arrangements for pursuing such suit or proceedings and distribution of the proceeds to the parties in such suits or proceedings in such manner and subject to such conditions as may be specified. So it is the responsibility of the COC who has, decided for the resolution of the corporate debtor. After subsection 2, the following subsection shall be inserted without prejudice to the provision of subsection 2. The adjudicating authority on receipt of the decision of the committee of creditors to dissolve the corporate debtor under subsection 2 of section 33 order that the corporate debtor shall be dissolved from the date of that order and corporate debtor shall be dissolved accordingly, provided that if an order under this subsection any asset of the corporate debtor remains with it, such asset may be disposed of in such manner as may be specified. As the proceeds thereof shall be distributed for the payment of insolvency resolution process cost, and may any surplus remaining after payment of such cost shall be credited to the insolvency and bankruptcy fund form under section 224. And notwithstanding anything contained. Notwithstanding anything contained in subsection 2 and subsection 2A, the passing of the resolution order shall not affect the continuation of proceedings referred to in subsection 1A and 1B. We have already seen it, that average transactions. In subsection 3, after word brackets and figures, subsection 2, the word brackets and figures or subsection 2A shall be inserted. After subsection 3, the following subsection shall be inserted, namely, 4. The adjudicating authority shall pass a dissolution order under this section within a period of 30 days from the date of receipt of the application under subsection 1 or the intimation of the decision of the committee of creditors to dissolve the corporate debtor under subsection 2 of section 33, provided that adjudicating authority has not passed an order within such period, 30 days, within period of 30 days. So the reasons to be recorded. Section 54A, all these are related to prepackaged. The only amendment made effective, these are not, mentioned. Just a minute. 35, 31, these are mentioned also. So only thing I want to tell you that this 66% for the initiation of PPIRP now has been reduced to 51%. Shall be substituted. The word 51% shall be substituted. Okay. The only thing that this section for 39 part chapter 4 shall be omitted, but this chapter 4 of the Principal Act, after that the following chapter, that 4A, has not been notified because this is credited CIIRP. I already said that CIRP has not been notified yet. No. Chapter 4 is your fast track insolvency. I already said the fast track insolvency is now omitted. And the chapter 4 of the principles now shall be omitted. 4A is not notified. CIIRP. So this section 59 relates to your voluntary liquidation process. Again, this chapter 5A group insolvency has not been notified yet. Section 61 is the appeal to the NCLAT, and it is mentioned in the amended act that the appeal should be disposed of within a 3 months period. The timeline for the disposal of appeal by the NCLAT is also now incorporated in the new act. Following sections shall be inserted. 64 is your expeditious disposal of application. The 64 new section 64 is if any person has initiated a frivolous or vexatious proceedings before the adjudicating authority under this part, it may impose upon such penalty which shall not be less than 1 lakh rupees but by instant to 2 crore rupees. So severe penalty has been imposed for any frivolous application. Section 66 is, fraudulent and wrongful trading. The marginal, for the marginal heading, the following marginal heading shall be substituted. If you see section 66, section 66 heading says the fraudulent trading or wrongful trading. Now it will be fraudulent shall be substituted, namely fraudulent or wrongful trading. Fraudulent trading, not fraudulent or wrongful trading. In subsection 1, after words resolution professional, the words liquidator shall be inserted. So both liquidator and RP can file the application. In subsection 2, the words during the corporate insolvency shall, the words by a liquidator shall be inserted. Okay. Section 67. It is not initial. Since that CIRP is not notified, so this section 67A also not notified. But section 67B has been notified where the corporate data or any officer contravenes the provisions of section 14. The adjudicating authority may, on an application made by the board or the central government or any person authorized by the central government in this behalf, as the case may be, impose penalty upon the officer who committed the authority or committed or authorized or permitted such contraventions, which shall not be less than 1 lakh rupees, but extend to 2 crores. Where the creditor contravenes the provisions of section 14, the adjudicating authority may, on application made by the board or the central government or any person authorized by the central government in this behalf, as the case may be, impose penalty upon such person. Again 1 lakh, but not may extend to 2 crores. So these are all penalties. So earlier this section 74 is omitted, which section is the contravention of the moratorium or punishment for contravention of the moratorium or the resolution plan. So this is omitted, but this section 67B, the new provision has been incorporated in the new act. Section 76 also omitted. Section 76 is your punishment for non-disclosure of dispute or payment of debt by the by the operational debtor, that is also omitted. This is important. This section 96, you know, that the interim moratorium for the personal guarantor. So what is mentioned in section 96 of the Principal Act? After subsection 3, the following subsection shall be inserted. Just a minute. It is an important amendment in the code. So after subsection 3 talks about the provision of this subsection 1 shall not apply to such transactions as may be notified by the central government in consultation with any financial service sector regulator. So after this clause, the following subsection shall be inserted. So subsection 4 is now inserted. The provision of this section shall not apply where an application is filed for initiating an insolvency resolution process in respect of the personal guarantor to a corporate debtor. So initial moratorium is no longer applicable for the application filed under section 94 or 95. Okay. No interim moratorium. In section 99 of the Principal Act, in subsection 1, the word 10 days, the word 21 days shall be substituted. Okay, that's time period for filing report under section 99. So earlier it was 10 days, now it is become 21 days. In subsection 10, for the word or the creditor, as the case may be, the word and creditor shall be substituted. In section 106 of the Principal Act, after the subsection 1, the following subsection shall be, subsection is the submission of report under section 100. After subsection, the following subsection shall be inserted. 1A, where no repayment plan is submitted within the period stipulated under subsection 1, The resolution professional shall submit a report to the adjudicating authority, and the adjudicating authority shall pass an order terminating the insolvency process of the debtor, and the debtor or the creditor shall be entitled to file application for bankruptcy under Chapter 4. Anything contrary to containing provision to for the repayment plan in respect of the debtor who is a personal guarantor to corporate debtor shall summon a meeting of the creditors by issuing a, just a minute please, subsection 3. Under 6, I told you the report of resolution provision on repayment plan, and 3 said the report referred to in subsection 2 shall also specify the date on which and the time and place at which the meeting should be held if he is of the opinion that a meeting of the creditor should be summoned. And now what's happened? Now it is said that a new section is now inserted, 3A, notwithstanding anything notice anything to the contrary contained in the provision of subsection 2 and subsection 3, where the repayment plan in respect of a debtor who is a personal guarantor to a corporate debtor. The resolution professional shall summon a meeting of the creditor by issuing a notice in writing specifying therein the date, time, and place of such meeting. So whether now you get the repayment plan or not, you have to call a meeting by specifying the date, time, and place. In subsection 4, after the word bracket figures for the purpose of subsection 3, word brackets and 3A shall be inserted. These are all the bankruptcy. So friends, more or less, I am through with this new clauses, new sections, provisions of the new act. Because these are all, I mean, not directly related to our activities for CIRP and liquidation. So what I want to share with you now, just a minute. Just a minute. Is it visible? My screen is visible? Hello?
Yes, sir. Yes, sir.
Okay. So friends, now I want to tell you that though almost all the provisions of the new act now have been notified through the notification dated 22nd May 2026, and it is mentioned it will come into effect with effect from 26th May 2026, but these 4 things are yet to be notified. It is not notified in the gazette, in the notification gazette. Yes. So what are these? The creditor initiated insolvency resolution process, CIRP, group insolvency framework, cross-border insolvency framework, and IBBI integrated electronic platform for monitoring the process. So the relevant section of the new act has not yet been notified, and obviously the regulation also not notified. So if you see that as mentioned in clause 7 of that notification of 6th April, section 11, amendment of section 11, in section 11 the principal act in clause BA, that is persons not entitled to make application, includes a corporate debtor in respect of whom the resolution plan has been approved under section 3A. This is the red which I have mentioned by red. It is the existing or the provisions mentioned in IBC 2016 earlier. Okay. Now the new act says that after the word figures letter, the chapter 3A, the word figures letter of chapter 4A. Chapter 4A is CIRP. Shall be inserted. So this thing is not yet notified. Obvious reason, the CIRP has not been, provisions for CIRP has not been notified. So insertion of new chapter 4A for the creditor initiated insolvency resolution process and section 58A and 58K, 258K has not been notified yet. Then the new insertion of new chapter 5A related to group insolvency procedure. This is also not yet notified. Section 65, which is for the fraudulent or malicious initiation of proceedings. In section 65 of the Principal Act, in subsection 3, the words prepackaged insolvency resolution process and the word prepackaged insolvency resolution process or creditor initiated insolvency process shall be substituted. This is also not notified because of that very reasons of not notification of CIRP. Now, this is the amendment of section 67A, fraudulent or management of corporate data during PPIRP. So, what was there in the new act in section 67A of the Principal Act in the marginal heading, the word prepackaged insolvency resolution process, the word prepackaged insolvency resolution process or creditor initiated insolvency shall be substituted. So the heading is also not notified. So it is still the prepackaged insolvency resolution process. Heading for section 67A. For the word prepackaged insolvency commencement date, the word prepackaged insolvency commencement date and creditors initiated insolvency commencement date shall be substituted. So it is also not notified. Amendment of section 208, functions and obligations of insolvency professional. In section 208 of the Principal Act in subsection 1 of clause CA, which is mentioned as prepackaged insolvency resolution process under chapter 3A of part 2, the following clause shall be inserted, namely, creditors initiated insolvency resolution process under chapter 4A of part 2. It is also not done. And very importantly, insertion of new sections 240B and 240C, which are related to electronic platform for facilitating procedures and power to make rule for corporate cross-border insolvency for 240C. No notification has yet been done. So this is the position of the new act, the effectiveness of the new act, implementation of the new act 2026. But only thing is that still that the necessary regulations to be published, because generally IBC is a procedural law. So many things depends upon the process prescribed by the regulations. But okay, pending those process where there is no connection with the regulations, everything is now notified. Now implemented. Like your application of the section for liquidation ongoing liquidation, ongoing CRP process, etc., etc. So this is the thing. So these are all from my side. If you have any question, I am happy to give answer. Anything you want to ask me? One thing I can tell you, all of you, that look, this time there is a major amendment in the insolvency. In fact, that's why I told that I like to see that what the code is called. Is it Insolvency Bankruptcy Code 2026, or I mean, though earlier amendment made, but the code is called as Insolvency and Bankruptcy Code 2016. Because earlier only 1-2 sections are amended or some insertion is made. But now it is almost all the provisions of the sections are now changed, or the new sections are inserted. So we have to be very careful. We have to have a very thorough reading of the new act to understand the nitty-gritty, because now everything will be monitored through that portal. Okay, though it is not yet notified, but definitely it will come. So we have to be very cautious. We have to be very careful in discharging our duties as the insolvency professional. And that's why we also require a very thorough knowledge on this new amended act for insolvency and bankruptcy code. So any question you have, or?
No, sir, just because of curiosity, the amendment for the 14 days timelines for the court and the 90 days timeline for the NCLAT, what do you expect? They will follow, or what is going to be happen?
Look, earlier it is not mentioned in the code. Code is the statutory document framed by the legislature. Okay. Now judiciary decision will be there. We cannot predict what will happen actually. But legislative intention is now very clear that everybody should try to complete, not try, everybody should complete the exercise resolution process, because otherwise there is no way, because this act is looked after by the everybody across the globe. So they always they compare their insolvency act with our insolvency act. So I think now at least some expeditious disposal will be expected. Otherwise, they have to mention the reason why it is not done.
Okay, sir.
Let's see. Anyone else? So, Anjali, you are there. Can we conclude the session?
Sure, sir. If there are no questions from participants, then we can conclude the session.
Okay. Thank you. Thank you all
Thank you very much, sir, for
for
such a wonderful session. Sir, please
thank you.
share the PPT for both the sessions.
I'll do that. I'll do that. And I thank all of you for your attendance.
Thank you, Mr.
Thank you, sir.
Thank you.
Thank you.